Hello, everyone. I hope you're all doing well. My name is Nathan Ozeroff Spicer, research editor at the Legal 500's GC Magazine and GC Power List. Thank you for taking the time to join us at this opening quarterly merger control series webinar, co-hosted by the Legal 500 and White & Case's global merger control team. We're gathered here to hear White & Case's panelists share their thoughts on a number of hot topics in the last quarter. This webinar will provide an overview of recent developments in merger control. The panelists will also discuss emerging theories of harm, the agency's focus on killer acquisitions and nascent competition, innovation, and vertical mergers, an update on developments in the MENA region, and capping off the webinar with an outlook towards the future. If you have any questions, please post them in the Q&A. We will have a few minutes at the end of the webinar to answer questions, and if appropriate and the opportunity presents itself, the panelists may answer some questions in real time. Additionally, if you'd like to speak with any of the panelists afterwards, please be in touch with them after the webinar. I won't go through every member of our panel's qualifications and experience. If I did so, I'll likely leave them just a few minutes to speak at the end. Instead, while I will give a brief summary of their respective areas of expertise, I recommend looking them up so as to learn a bit about their extensive breadth and depth of their expertise. Tillman Kuhn is an antitrust and FDI partner at White & Case in Dusseldorf and Brussels, with particular expertise in large international merger control cases. George Paul is an antitrust partner at White & Case, based in Washington, D.C. He advises clients on a range of international competition issues, with particular focus on merger clearances, cartel defense, and litigation. Senzen Cengiz is a Turkish competition law counsel with 21 years of expertise, has been leading the Turkey practice since 2011. Prior to joining White & Case, she worked as a senior case handler at the Turkish Competition Authority for 10 years. Tamer Nagy is an antitrust counsel at White & Case in Washington, D.C. and Cairo, Egypt. His practice focuses on complex merger control matters with a focus on the Middle East and North Africa. With introductions out of the way, I want to thank all of you again for attending, as well as thank the panelists for speaking today. I'll now hand it over to White & Case team. I'm sure we'll all learn a lot today.
Thank you very much, Nathan, and let me kick it off. Thank you very much, everybody, for joining our first inaugural session of our new quarterly merger control webinar. We're going to be trying to focus on global developments in the last quarter, but also deep dive on a number of pressing issues to give you a good overview of what's been happening, what's coming, and what are the issues of debate today. This is a webinar that we will try to do every quarter, and we will try to keep it to roughly 45 minutes, not to carve out too much time out of people's busy schedules. There will be an update of the recent developments and an outlook that will be really more like a headline summary of things, not to belabor the point specifically. But as I said, there will be a deep dive on specific issues that will change from one quarter to another. And there will always be a regional or country update. And this all complements other publications and thought leadership that White & Case publishes regularly. We have recently started a first reflection series of webinars that provides quick feedback a few days after an event, such as in that case, the Illumina Grail judgment. We have alerts basically on every key merger control development around the globe. And we have also introduced our WAMS, the White & Case Antitrust and Merger Control Stat Pack that shows you just statistic trends. I would also like to say that there will be a recording of this session available both for the entire session, but also for individual segments, and you will be able to find that on our website. Let's start then with the recent developments before we deep dive on our main topic today, the emerging theories of harm. Then we go to a MENA and Turkey regional update, and then we finish out with an outlook. On the recent developments, just very briefly, what are the trends that we've seen in the first semester of 2022? We've seen a notable decline in M&A activity and accordingly also in merger control activity. Just looking at 3 jurisdictions here, there's been a clear decline in the US, a clear decline in Europe. Interestingly, quite an increase though in Brazil, and we see that also in a number of other regions. I'll leave it at that just in terms of trends. And again, you're welcome to visit our website to look at these statistics in more detail. Looking at the EU specifically, we've had a series of judgments by the European Union courts focused on merger control, which is quite unusual because not that many cases end up in court here. We had two judgments on damage claims brought by parties that have been affected by a merger prohibition that was ultimately annulled by the European courts. And the takeaway here is it's very, very difficult to claim damages, even if the European Commission's merger veto is ultimately annulled. The causality of damages is very hard to prove. We had an important judgment on warehousing. That's the Canon Toshiba judgment, a very specific structure in which the seller tried to obtain the purchase price early on before merger clearance. And the European Commission fined the parties for early implementation, or gun jumping as we call it, and the General Court confirmed the EC's fine in that respect. Then we had two judgments on substantive issues involving prohibition decisions by the European Commission. Commission had blocked the Wieland Werke Aurubis rolled products merger, and the General Court upheld that merger veto. An interesting case in terms of a mix of horizontal and vertical effects of a merger and which analytical framework applies to these. And also a very important judgment in terms of remedies, because it is a clear illustration of the increasingly strict stance of both the EC and endorsed by the EU General Court, that remedies really need to be viable and stand alone, and a very strict standard applies here, even where the remedy is a so-called upfront buyer remedy. The second judgment on a substantive prohibition was the ThyssenKrupp's Tata Steel joint venture. Again, the most interesting part is probably around the remedies assessment. So if you're dealing with this type of question these days, I would encourage you to read our alerts on this and of course the original judgment. And then last but not least, we've recently had a very, very interesting procedural or jurisdictional judgment on the Illumina Grail case. That is a case that will feature prominently also on our deep dive session here on innovative theories of harm. But the judgment is solely on the question of whether the EC had jurisdiction to review the case, because this was a transaction that did not trigger any merger filings within the EU, because Grail had no revenues whatsoever in the EU, but still some of the authorities referred the case to the European Commission under Article 22 of the merger regulation, and the General Court endorsed the Commission's jurisdiction, both in terms of allowing transactions to be referred even if they don't meet the national filing requirements, and in terms of the timing of that referral. Last but not least, on the EU update here, on the legislative front, there's not that much happening. We do have an ongoing consultation on a simplification package. Every couple of years, the European Commission revisits its merger control process and tries to figure out whether there's a way to ease the burden on companies in cases that do not raise concerns. So we have a new initiative here, which most interestingly features a sort of a tick the box type of exercise for certain simplified cases. The consultation ended in June, and likely the package will be adopted in the first or the second quarter of next year. With that, let's pass it on to George for a US update.
Thanks, Tillman. At a minimum, what I hope that you'll take away 2 points today regarding the United States. The first is that the Biden administration, in a sharp departure from previous Republican and Democratic administrations, wants to replace the current antitrust laws with a fundamentally new standard. And this means they don't want to be seen as approving or settling mergers that create larger, more efficient competitors. Alvaro Bedoya, who's the FTC's newest commissioner and was appointed by President Biden, said just last week, antitrust is for regular people. It's a law designed to protect them and promote fairness. It's time to return to fairness, he says. He doesn't know what is efficient, which is the current standard, but we know what's fair. The second point follows the first very importantly, which is that so far courts aren't buying into this new regime, and parties are still getting clearance on their transactions. So storm clouds on the horizon. Oh boy. So with that, you can't rewrite the laws overnight, but there have been changes that have been made by the Biden administration to implement structural and procedural roadblocks to discourage borderline deals or block other deals without the need to win on the merits. And these are listed here on the slides. This is necessary for them because the substantive changes take longer. And as we are seeing, the substantive changes may be more difficult to clear. This has important implications for merger clearing, as a deal killed by process is still a deal killed. And the first category of roadblocks we see are mainly temporal, starting with the suspension of early termination, a tool that was used to quickly clear transactions between parties with no competitive overlaps. Others are reduced staffing on controversial mergers, the increased issuance of second request without probable cause, all of which are slowing reviews. And importantly, the agencies are moving away from remedies, from settling merger cases. Recently, the head of the Department of Justice Antitrust Division, John Cantor, said, "In my view, when the division concludes that a merger is likely to lessen competition or create a monopoly, in most situations, we should simply issue an injunction to block the transaction." He argued that asset sales or divestitures cannot fail because the company that buys them won't make full use of them. For parties, these things raise the stakes, particularly where you might have an overlap of just one product out of dozens or one city out of hundreds. Those can land you in court after a time-consuming, money-draining 2-year agency review. And Assistant Attorney General Cantor knows that even the parties that win in court could lose under the burdens imposed by the DOJ. So with that cheery note, I'll send it back to you, Tillman.
Thank you. And just a very quick overview of a couple of other parts of the world and what's been going on there. Some interesting legislative reforms that are in the making or likely to be adopted or have just been implemented. But also we see some interesting procedural and substantive trends. So in Canada, for example, the most interesting update I saw was the introduction of an anti-avoidance provision. So the Canadian Competition Authority wants to make sure that people don't circumvent the merger control regime by structuring their transactions in a way intentionally to avoid filing requirements. I also think that we see the same trend as in many other mature merger control regimes, that we see more remedies and stricter remedies in merger cases. On the procedural side, we see an increased focus on gun jumping. CAGE in Brazil recently imposed the maximum available gun jumping fine in a recent case. The same goes for the Mexican authority that has had a large number of gun jumping cases in recent months. Interesting legislative development from India, particularly important merger control jurisdiction. A new threshold is being introduced that relates to deal value. We hopefully see some expedition of merger review timelines, although we'll have to see how that works out in practice. The standard for what is a concentration, what is a reportable type of transaction may change, because now it's more of a focus on material influence rather than decisive influence, which is, for example, the EU standard. And a welcome change is the introduction of a derogation of the standstill provisions for stock market acquisitions. But at the same time, we also see an expansion of the scope of gun jumping provisions. These reforms will likely enter into force later this year. Australia, a very important jurisdiction in which we as a firm have also recently expanded our practice and coverage. The ACCC, the Australian Competition Authority, continues to push for a mandatory pre-closing and therefore suspensory regime. As you may know, currently it's a voluntary regime. And they're particularly interested in thinking through how to deal with acquisitions on involving minority interests rather than the acquisitions of control. And we also see the same trends as in many other jurisdictions, a very large focus on mergers involving digital platforms and on remedies transactions. And then last but not least, quite interesting, I thought at least, that in Indonesia and Thailand, we've seen fines for delayed merger notifications. These feature inter alia post-closing filing requirements that come with certain deadlines. And if you miss those, apparently you can be fined. That's it for the overview of recent developments. Let's dig into our main topic today. What are emerging theories of harm? I always like to start with this slide whenever I talk about merger control developments and trends. And this just shows you the intervention rate of the European Commission in mergers. And that gives you a bit of a sense of, is the environment getting tougher, yes or no? And intervention is something that involves either a phase 2 or a phase 1 with remedies, and then the phase 2 may end with or without remedies, or the transaction is blocked, or the transaction has to be withdrawn because of objection. So anything but a phase 1 clearance without remedies would be an intervention when you look at these numbers. And whenever the European Commission talks about merger control trends, they focus on the penultimate line here that hasn't really changed that much over the last 17 years. The overall intervention rate has stayed between 6.5% and 8.5% throughout that time period. If you look at the last row here, though, then I think you do see a market difference, and that is really all the cases excluding simplified cases. So the ones that on their face already raise no competitive concern. So if you have a case that is not a simplified no-brainer, if you allow me the term, then you have a chance of almost 1 in 3 that your case will require remedies or at least go into phase 2. And I think that's a quite stark number that you have to keep in mind. There may be an element of the expansion of the scope of the simplified procedure that tweaks the math here a little bit, but I do think it's very consistent with what we practitioners see as increased scrutiny on mergers, especially under the current competition commissioner that took office in late 2014. This coincides with a focus on innovation in merger control cases. It's always been there. It's always been an element of competition that's been important, but it features much more prominently in official speeches, in decisions, in press releases relating to mergers where there were interventions. Innovation really, to me, has 3 dimensions if we think about it a little more technically from a merger control perspective. First, it's just a synonym for product quality, consumer choice, and so on. So that's not particularly remarkable. But then we see it traditionally, especially in life sciences, healthcare, pharma mergers, where the competition authorities have for a long time looked at not only competition between existing products, but also competition between an acquirer's existing product and the target's pipeline product, a product that is not yet on the market, but may well come to the market quite soon. This is quite similar to a standard potential competition analysis, so a merger with a potential competitor, but we do see quite some trends over the last, let's say, 5-6 years in this space. There used to be a clear focus on competition between an existing product, say that of the acquirer, and the target's late-stage pipeline products, right? So products that are quite close to the market and have a high probability of coming to the market, and where predictions of their success may be quite reliable. Over time, the Commission went back further in the pipeline and expanding its assessment to products that were even in early discovery stages. And then it went outside of the realm of pharma, where you had quite good data in terms of, is it a phase 1, phase 2, phase 3 pipeline product? How long does it take until it makes it to the market? What's the probability? And also looked at a merger's impact on innovation efforts in the GE Alstom case, where it required a substantial divestiture because it was concerned that the merger would dampen innovation efforts of the combined entity going forward. And it relied heavily on internal documents in that respect. In Dow DuPont and Bayer Monsanto, the big agricultural mergers, the Commission went even a step further, but still within the realm of the initial pipeline analysis, and went further back in time and looked at innovation efforts regarding overlapping lines of research. So we were really even before the actual discovery stage where you could identify a potential product. It also really went on to come up with a real revolution in the agricultural mergers, because in addition to this focus on early pipeline and discovery targets, the Commission came up with an entirely novel theory of harm, and we call that the industry level theory of harm, where basically just because the number of quote unquote real innovators in an industry is reduced, the Commission thinks there will be overall less innovation in the industry. The idea here is that there's just a couple of companies in an industry with the global capability, the global footprint, the budget to come up with innovations year over year over year. And if you reduce the number of those and thereby you reduce rivalry between them, there will be less innovation in the market. Commission felt it doesn't need even to identify which products will not make it to the market because of the transaction. It's just enough to say there will be less innovation effort and therefore overall less innovation and less products on the market. Parties argued that, well, if their rivalry is reduced and if they have less innovation output, their rivals may step in to fill the gap, but the Commission felt that they either lacked the capabilities or the incentives, for example, because they had common minority ownership structure with the merging parties. So that leads us to the question of what has happened since those agricultural mergers and the introduction of the new industry level innovation theory of harm. At the horizontal level, we actually haven't seen many new cases. There's been a big political and policy debate around killer acquisitions, which really is the idea of an acquirer with an existing product buying a target with a pipeline product with the intention to quote unquote kill that pipeline product so it doesn't become an actual competitor, and therefore the acquirer can continue to obtain monopoly profits. We haven't really seen at EU level any cases that have focused on this. There's been some in the UK, the Illumina PacBio case. There's been some in the US, and George will talk a little bit about that, often under the headline of nascent competition, but not really much case law that we can analyze here. There's been a discussion of what type of killer acquisitions may exist in the digital industry, and I like to call them zombie acquisitions, because the idea really is not to kill that pipeline product or target, but to keep it alive. And the idea here is there's maybe an overall effect of innovation if big incumbents buy up startups, and these startups have maybe a complementary business model and may turn into a real competitor if they're left alone. Maybe also the initial incentive to innovate in the first place, to come up with a new startup project or company, is going to be somehow hampered by the strategic and serial acquisition of startups by big tech companies. But we haven't seen really any case law on that, at least in the EU either. What we've seen recently is a lot of focus on verticals and conglomerate mergers, and we've actually seen the first ever prohibition of a purely vertical merger with the Illumina Grail prohibition just a couple of days ago. So let's look at those and let's see whether there are any novel theories of harm or whether we just have the standard analytical framework applied to a somewhat more modern industry. And then last but not least, I'll say a word about sustainability, because that's also on everybody's mind. And there's not much case law on sustainability effects of transactions yet, but it may be worth a couple of words on that too. If we look at some of the recent cases, I'll focus on three, and I'll give you the high-level takeaways very briefly. Meta Customer, a case from January 27, 2022. That's the date of the decision. Unfortunately, we don't have the published text of the decision yet. But this is basically about a CRM, so customer relationship management software, that a customer as the target made. And Meta, formerly Facebook, has, of course, important messaging channels such as Facebook Messenger, WhatsApp, and Instagram. And these are actually input for that CRM solution that combines input from and data from these messaging channels. And here we had a vertical theory of harm. The Commission found that Meta would have the ability and the economic incentive to engage in foreclosure vis-a-vis customers, close rivals, and potential new market entrants. It was concerned that Meta would deny or degrade access to its APIs that are needed for the CRM providers to work with the WhatsApp, Instagram, and Facebook Messenger data to come up with their own CRM solutions. So the EC ultimately cleared the transaction, but with very, very substantial remedies, and those were access commitments primarily. Access to these APIs and access to any improvements of these APIs for the rivals of customer, current and future. What's quite interesting is a jurisdictional aspect here, and I won't go into detail how that came about, but the case was ultimately referred by national competition authorities to the EC, but the German competition authority, the FCO, took the view that it has jurisdiction and it will not refer the case. So you had a parallel review by the German competition authority. And if you look at the statement of the FCO's president, Andreas Mund, on the clearance decision, which of course took the EC's case and findings into account, you see that they were also looking at a broader concern here, whether there's somehow a broader impact on Meta's overall strategy by this strategic acquisition of a startup company beyond the individual vertical aspects that already the European Commission had taken into account. And the conclusion that the FCO reached was that with some unease, they had to acknowledge that this is not something that they can capture under the current analytical framework. So they felt there's maybe more to it than just the vertical theory of harm, but they didn't feel they have the tools or the substantive standard to catch that. Google Fitbit is another case, to some extent structurally quite similar. Again, it's a vertical theory of harm. Again, it has something to do with access to data. And we had quite an unusual and hefty remedy package. We had, for the first time, a silo commitment that Google was allowed to have the data, but not use it for Google's online ads. And again, there was an API access commitment and an interoperability commitment that we've seen in tech cases, both in merger control and in abuse of dominance cases already in the past. Last but not least, the Illumina Grail case. Again, prohibition is just from roughly 3 weeks ago. We don't have a published text yet, but we have a press release from the Commission, and some commentators have made some remarks here. Again, it's a purely vertical case in the pharma and life sciences industry. Illumina is upstream and makes next generation sequencing systems for genetic and genomic analysis and cancer tests. Grail is basically using that technology to develop its tests. Currently, Grail is the only company that has these tests on the market, so it's the only customer of Illumina. But the Commission was still concerned that there may be companies working on competing tests and coming to the market at some point, and that Illumina could then foreclose them from access to basically promote Grail and protect it from its rivals. There seems to be a big debate, or have been a big debate, around how likely it is that any competitors would come to market with their own cancer tests in the near future. So the argument would be, if they don't come to the market in the next couple of years anyway, the merger cannot be causally linked to any foreclosure effects. But the European Commission was apparently convinced of its concerns, and also the behavioral remedies that Illumina offered did apparently not adequately address the EC's concerns. That's quite remarkable, because a vertical case is about foreclosure, so it's about the future conduct of the merged entity, and therefore behavioral remedies should in principle be the appropriate way to address these concerns. But again, we see a trend towards much stricter stance on remedies, and this seems to be consistent with it. What's not entirely clear, but it seems from the press release that maybe the Commission went beyond its traditional analytical framework here and came up with a vertical extension of its Dow-DuPont innovation theory of harm, because it was concerned, according to the press release, really more broadly about innovation efforts and how this merger could discourage competitors of Grail to come up with their tests or bring them to the market, because they were concerned about foreclosure. Illumina has appealed the prohibition decision, so hopefully we'll have some more transparency on this sometime soon. Last but not least, just very briefly, question: is there already a sustainability theory of harm, or are there sustainability efficiencies that are being taken into account by the European Commission? The answer is not really. Sustainability can be introduced somehow in different ways into merger cases. But in terms of theories of harm, it's really just the Arubis Metallo case that, according to the press release initiating phase 2, there was also some concerns about environmental effects of the transaction, especially less recycling of scrap, but that concern was ultimately not sustained. So we'll have to see how that develops. With that, I'll leave it for the EU, and I'll pass it over to George for the US developments in this space.
So unlike Tillman, who spent a little bit of time trying to determine whether these are new theories of harm or the same old theories of harm dressed up slightly differently, in the United States, what we're seeing is unabashedly novel. The United States antitrust agencies, buoyed by the White House, have embraced the biggest bad philosophy when assessing antitrust issues, whether it be in the technology sector or even broader. Leadership believes that the traditional antitrust laws, such as the Consumer Welfare Standard, which looks at efficiency, are inadequate to address modern challenges facing the modern economy. And what they're doing, and they are increasingly unified and developing multi-dimensional approaches to challenging conduct and to mergers, including deals that are neither horizontal nor vertical, instead ecosystem driven or concentric or conglomerate, as Tillman referred to. Shying away from traditional market analysis to a more ambiguous market realities test is the plan to have. And there's no better example of that today than the Meta Within transaction, which is currently under investigation by the FTC, who is moving to challenge it. Meta has agreed to acquire a small but innovative virtual reality tech company. The deal will enhance Meta's overall virtual reality portfolio, in particular by adding the fitness category to its offerings. The FTC is arguing that the acquisition of the new users, content, and developers would all feed into one another and create a self-reinforcing cycle that entrenches Meta's lead, not only in virtual reality, but in social media. Now, it's axiomatic that this kind of market dynamic can spur companies to compete harder in beneficial ways by, for example, adding useful product features or hiring additional employees. But the FTC is arguing here that the network effects of putting Meta's virtual reality into Meta's portfolio, these network effects also create anti-competitive strategies by acquirers. So the FTC is essentially saying Meta doesn't have the capacity to innovate for itself. So what it does is it finds market leaders and acquires them rather than using its money to build a competing product. The FTC alleges that this kind of strategy harms innovation and competition. Many would argue that this kind of innovation and competition and the ability of small companies to be acquired actually improves innovation. That was the Obama administration. The FTC alleges, however, that Meta is acquiring Within instead of doing something on its own, and this ecosystem will make it impossible for other providers to actually try to enter into the virtual reality space. It's not saying that Meta has a monopoly in fitness apps. It's not saying that Meta has market power in virtual reality programs. Instead, the FTC is concerned that Meta is using its financial power, its bigness, gained from its success in other markets, to assemble a fortress in virtual reality that no newcomer will be able to successfully besiege. We'll see how the FTC court system and federal courts review and decide on this. Now, on the other side of the coin, we have another tech deal involving Microsoft and Activision Blizzard. And Activision is a game company that has the popular Call of Duty, World of Warcraft, Candy Crush, and Guitar Hero franchises. And they are being acquired by Microsoft, which operates its Xbox, which is the leader for consoles for these games to play on. And what is emerging, in addition to the vertical issues that are similar to those that Tillman was discussing earlier, for the FTC, a major focus is on labor. Regulators are looking at whether the combination of the two could harm the game developer labor market. So workers in the past have accused Activision of discrimination in a hostile workplace. And so in a June 9th letter to Senator Elizabeth Warren, the FTC chair, Lena Khan, confirmed that the agency is investigating the proposed deal with a focus on its impacts on Activision workers. Given the past allegations of sexual harassment, of hiring discrimination that have been lobbed against Activision, as well as some recent unionization in the video game testing market, the FTC is focusing on whether non-compete clauses or non-disclosure agreements that are ancillary to the overall transaction could violate the antitrust laws. This one's one to watch. The FTC's investigation is ongoing, and it'll be interesting to see if they take action. We have seen that the FTC has been taking action. As I mentioned before, the Department of Justice in particular is pursuing a no settlement policy. And the United Healthcare change deal was an example of a transaction where they refused to sell. It was the collision of this refusal to resolve combined with the deal that the parties went ahead and fixed on their own without the Department of Justice. And in that deal, which involved, it was in the healthcare sector and also involves technology, To resolve the horizontal overlaps, the parties entered into an agreement with a private equity firm to acquire the sole horizontally overlapping product. Now, DOJ insisted the fix would not maintain competition at pre-deal levels. The court, however, said that the DOJ was looking at it wrong and instead bore the burden of showing that the fix would substantially lessen competition, which is the standard under the Clayton Act. And that's a higher standard than just showing a change in competition from pre-deal levels. So the DOJ's refusal to settle led to them losing on their vertical theories. And this is an important case, and it demonstrates where parties' documents are clean, and there's a history of non-discrimination in the industry and industry practice, it's going to be difficult for the government to prove the elements necessary for a vertical claim. And it also shows that if the parties can fix the part of their deal that does raise real competition issues, here the horizontal issues, then they stand an excellent chance in court of getting their transaction approved, even if the agencies are refusing to settle. Most notably, this was a loss that happened last week, and we'll learn more, but it's not their latest loss. On Friday, the DOJ lost another case in the sugar industry, that is too soon to see. The decision's not out quite yet on the details of what the court found there. And another deal, DOJ has moved to block a merger on the basis of one contract in which Booz Allen and Everwatch are the only two likely bidders. Here, what we see is this DOJ emphasis on market realities and suggests that the DOJ might scrutinize and even challenge deals where there is any direct evidence of head-to-head competition with implications for market definition going forward. So this is more evidence of them focusing on competitive effects instead of the traditional market analysis. I would say I don't necessarily think this is a bad thing to examine market realities, but it is extreme to bring a case where the only time the parties are raising any competitive issue is on a single contract. This means it's going to be important for companies to undertake an extremely broad view of how they may compete with a merger party, and even small things may result in a challenge. Now, I don't want to spend too much time on Illumina Grail because I thought Telman did a great job of describing that, except to say that in the US, where Illumina and Grail actually compete or actually operate, unlike Europe, the FTC considered the same issues, and the court found that the deal was not anti-competitive at all. Here, the staff of the FTC was worried about more of this moat building, Illumina buying up Grail to keep others from competing. But the judge that looked at the matter after a lengthy trial at the Federal Trade Commission found the merger would not increase Illumina's market power because it was already a monopolist, and that Illumina had made an offer to supply current Grail rivals for the long term, that was sufficient in the marketplace to prevent harm to rivals. So another significant loss for the FTC. I will add that the FTC has the ability to appeal this decision, and they've indicated that they will. With that, over to Tamer Nagy for his views on the rise of Middle Eastern antitrust.
Thank you, George. That's right. In the Middle East, we've been seeing an upsurge in merger control enforcement across multiple jurisdictions. And I'm going to keep it very high level and short because there's a lot to cover across this region, but happy to discuss separately if anybody has questions later on any of the jurisdictions. So, for example, in Egypt, we've been seeing an increasing role for the Egyptian Competition Authority in pre-closing, in reviewing transactions pre-closing, even though the regime in Egypt is actually a post-closing notification regime. This is because there have been a number of regulatory agencies that typically have to approve deals in certain sectors, such as in healthcare, pharma, telecom, and banking, that have been referring the cases to the ECA for review, and therefore giving it more of an authority and more of a role in these transactions before closing. Same thing is happening with COMESA. COMESA has been referring cases to the ECA where there is a transaction that has some nexus to Egypt, and as a result, we've been getting inquiries from the ECA for transactions that haven't even closed yet. In Kuwait, which has just passed a new merger control regime about less than a year ago, they've been actively enforcing this new regime. and recently expanded it to include foreign-to-foreign transactions. Initially, it wasn't very clear if the CPA, the authority in Kuwait, was going to apply it, but recently they've been confirming that even if the target has no presence in Kuwait, if any one of the parties has some business activities in Kuwait, that has technically been triggering filing there as well. And we are aware of the agency contacting a number of companies to ask them why they did not file for certain transactions. Morocco, which has also been active for the past few years, have just imposed their first fine. They imposed a fine of more than $1 million against the Swiss company Sika, which is active in chemical construction, for their acquisition of a French company that is active in the same space. Now, while both companies, the transaction happened in Europe, there was an indirect share transfer among their subsidiaries in Morocco that piqued the authorities' interest. Meanwhile, in Saudi Arabia, they blocked the first deal on substantive grounds. And unlike in Europe, where the first time to block a deal on vertical grounds was just recently, Saudi Arabia's first deal to block on substantive grounds was on vertical concerns, which was very interesting. This was in the sector of liquid petroleum gas. The authority there deemed the buyer to be a monopoly in the field, and they had concerns that the acquisition would foreclose competition against the target company, it's called Best Gas. Now, moving on, looking forward, we're expecting more enforcement to come across the region. Again, Egypt, like we said, currently is a post-closing regime, but they have been discussing draft amendments to the competition law that would transform the country's merger control regime into a pre-closing one. This has been highly anticipated for years and has been pushing some pushback on and on from a number of stakeholders and other interest groups. But the latest reports indicate that this law is expected to pass by the end of this year, which would, of course, transform the jurisdiction of the agency there quite a bit. Qatar, which has not been an active jurisdiction, has also been rumors that they are getting increasingly active. We are hearing of the authority contacting certain transactions that have not filed, which is a sign that they too are starting to activate their merger control regime. Lebanon has also just enacted a new merger control law earlier this year, although it has not come into force yet, and we're still waiting for the implementing regulations to come. But in addition to the national efforts for enforcement, we're also seeing a lot of efforts to establish regional frameworks that are bound to bolster enforcement across the region. So, for example, the Arab Competition Network was just launched earlier this year, establishing a network for 17 member states, Arab member states, headquartered in Egypt, and it was launched at the headquarters of the Arab League. And the goal of it is to improve and increase collaboration among the member states in enforcement, including in merger control. There's also the African Continental Free Trade Agreement that is currently under negotiation, that has already been signed by 54 countries in Africa, including those of Northern Africa. And the idea is to set up a framework to negotiate a number of policies moving forward that would help streamline trade and economic policies across the region, including among them competition policies. Finally, there's also been a various flurry, really, of memorandums of understanding, bilateral MOUs among countries in the region to help each other collaborate on competition matters, including on enforcement on merger control. The latest of which was between Egypt and South Africa. And there is a lot of expectation that this will also result in increased merger control enforcement across the region. So it's quite a dynamic region with a lot going on. Turkey is no exception. So I will pass it on to Sezin to cover the Turkey update.
Thank you very much, Tamer, for this nicely summarized merger control tour within the MENA region. As for Turkey, a country which seems to be currently undecided as to whether it belongs to EMEA or MENA region, we also have updates. very recently, in March this year, significant changes have been made in the Turkish merger control rules. First of all, the turnover thresholds have been significantly increased for the first time in years. Now the local threshold is approximately $28 million, whereas the global threshold is $340 million. This represents an 8-fold increase compared to previous years. At first sight, you would think that this increase in the turnover thresholds would decrease the number of merger notifications to the Turkish Competition Authority, the TCA. However, in my opinion, the so-called technology exception will not let this happen. Based on the new rules, if the target is considered a technology entity, the local turnover threshold will not apply, and the transaction will be subject to merger filing regardless of its turnover generated in Turkey. The technology entities in the new legislation are listed as those operating in digital platforms, software and gaming software, financial technologies, biotechnology, pharmacology, agricultural chemicals, and health technologies. Needless to say that this change is aimed to have more control over killer acquisitions in digital markets, or zombie acquisitions, as Tillman has referred to earlier. As you see, the list is pretty wide, and at this point, there is no guidance as to the details of this list. Accordingly, until such guidance is published, we would suggest to be cautious and notify all transactions to the TCA in case the target company may be considered to fall into one of these categories in terms of its operations. This is to avoid a potential gun jumping fine, which is significant in Turkey. Another significant change is the introduction of the significant impediment of effective competition, the so-called SİEK test. Previously, the Turkish Competition Authority would only make an assessment on whether the notified transaction would lead to dominant position and unconditionally approve the transaction if no dominance is created or strengthened. Now, with this change, the Competition Authority will also make an assessment on whether the transaction will lead to significant impediment of effective competition, which is by nature a more subjective assessment. We therefore would think that this change will give more control to the Competition Authority over the mergers. Lastly, the notification form has changed. So as you see, we have a brand new merger control system in Turkey. The biggest change relates to the scope of the requested market data, which depends on whether the transaction leads to overlapping markets. In case of no overlaps, it's a pretty straightforward notification form with almost no market data requested. In case there are overlaps, life will be harder when responding to very detailed market data. Since the pandemic, the TCA has been accepting electronic submission, and it seems like it will transition to a fully electronic notification form shortly, which will make our lives easier. Next slide, please. So this is a slide that I included to show how active the Competition Authority is in years as to merger control. As you see, last year, the number of merger cases has increased by more than 40%. And with the newly introduced technology exception, we expect this number to be even higher going forward. And lastly, next slide, please. What can we expect going forward? As discussed, we do expect in the short term an increase in number of merger cases reviewed due to technology exception, and an increase in remedied transactions due to SİEK test. Additionally, we observe that the Turkish Competition Authority has been closely following the EU Commission's review processes and decisions lately. Within the past year, the Competition Authority has granted approvals to 2 transactions subject to the very same remedies submitted to the European Commission. Accordingly, in case a transaction is notified in multiple jurisdictions, including in the EU, it is now more important than ever to make sure that the submissions are consistent, both in terms of the information provided and in terms of the strategy as to potential remedies. We also expect further scrutiny by the Competition Authority over gun jumping and pre-merger information exchange, parallel with the approach in the EU. In particular, The parties carrying out transactions outside of Turkey should make sure that they carefully consider any filing requirement in Turkey, especially based on the new technology exception. And for the transactions involving entities in Turkey, the parties should make sure that they have the appropriate clean team arrangements in place. Finally, we're also expecting a new legislation in Turkey, which is expected to be similar in some aspects to the Digital Markets Act in the EU, but the details are not yet out, so it may be a discussion point for another webinar, maybe once enacted. With that, I pass it on to Tilman once again to talk about the outlook.
Well, thank you very much. And really, we live in interesting times. That's pretty clear. To wrap up, I think there was the global head-to-head race between the EC and the US agencies about innovation and enforcement of merger control. The EC went ahead and took the lead in 2016, 2017 with the agricultural mergers and coming up with the industry-level innovation theory of harm. It's been a little more hesitant and has not applied it since then. We haven't seen horizontal killer acquisitions or zombie acquisition cases. We've seen more focus on verticals and conglomerate mergers, but it's largely the old analytical framework with some novel jargon like ecosystem and data access and what have you. Possibly Illumina Grail is again a turning point with an extension of the industry level theory of harm to vertical mergers. But one of the big issues and differences with the US is really it takes a long time until the decisions are published and effective court redress doesn't really exist. It takes at least 3 years until you have a court judgment, whereas in the US, we see quite an opposite development in the agricultural mergers. The DOJ did not buy into that industry level theory of harm, but in the meantime, it's overtaken the EC on new theories of harm, especially in the digital space. But again, we already have court judgments and the courts are not buying into it. Also, the focus on evidence is different. Of course, in the US, you have depositions, and that those play an important role, testimony by the C-suite, whereas in the EU, neither in the EC process nor in the court process, you hear witnesses and take that as evidence. So very interesting, also very interesting to see how the global proliferation of merger control regimes continues in the MENA region and how a mature system like Turkey also kind of reinvents itself. Quick outlook on the EU and on the US, and then we'll wrap up. On the EU, what are we seeing in the next couple of months? The Digital Markets Act will enter into force, which will feature an obligation for gatekeepers as defined in DMA to notify the EC of transactions that involve other core platform service providers. We will see Advocate General opinions at the EU's General Court, both in a case that will revisit the question, continental can Article 102 be applied to transactions below the merger filing thresholds? We will see the CK Telecoms Advocate General opinion, which was a very important merger prohibition annulled by the General Court and now appealed to the ECJ, which deals with the standard of proof, the burden of proof, the question of closeness of competition, and whether there's a efficiency presumption. And then we will also, on the legislative front, see some further developments. The updated EC market definition notice will be adopted in the first quarter, the merger simplification package in the first or the second quarter, and then in mid-2022, we will have the foreign subsidies regulation that will come and introduce a new type of proceeding in addition to merger control and FDI for certain types of transactions. Heading over to George for the US.
Sure, just to wrap things up, expect more aggressive changes coming from the agencies. We're going to see new merger guidelines that are designed to help the government block more deals be issued, perhaps as early as this year. That means increased risk, and that risk should be reflected in your deal document. So it's time to make sure, for antitrust lawyers, make sure your M&A guys understand this, and things like hell or high water clauses are something to be much more wary of than perhaps they were in the past, even for deals where you're not anticipating significant issues. Continue the distaste for settlement at the agencies means second request compliance is becoming almost mandatory to force the government to close their reviews and not just run out the clock and have the deal die. All is not lost though. Courts are saving grace. And there's an increasing sense that because the agencies are seeming to try to enforce against everything, that they're missing individual deals that might otherwise have gotten a close look because they're simply overwhelmed with the flood of deals they're trying to examine. And finally, I just want to point out again, going back to Illumina Grail, it's a great example of agency cooperation, or as I would call it, cartel-like behavior among enforcers to collectively work to block transactions. There, where the US agency was unsuccessful, its work in Europe led to a transaction being blocked. And with that, Tillman, I'm all set.
Thank you very much. Thanks everybody for listening. We have run out of time for questions, but again, if you have any questions on the presentation or anything else merger control related, please feel free to reach out to us. We will be back in December with the next quarterly series, and we'll have a somewhat similar structure, a recap, some focus issues, and a regional or country update. Please also visit our website, which has a host of materials, alerts, and statistics on merger control. And again, thank you very much. Have a great day.
And signing everything off, I do want to thank everyone who's joined us to speaking today. It's been really enlightening. I'll be watching through this again later just to make sure I've caught everything. Wishing everyone all the best and have a great day as well. Bye.